Hey everyone, welcome to Godless Bitches 3.0. I'm Jen Aldrich.
I'm Jenna Belk.
And with us today we have Johnny Angel, who is a practicing attorney who at one time practiced constitutional law, to help us out a bit with some of the cases that we're covering today in this episode. So this episode looks a little bit different. We are all currently dealing with COVID-19 here in the US and around the world. And because Jenna and I don't need to be in the studio today, we have decided to remote in to stick to the stay-in-place guidelines so that we don't infect people and we don't become sick. Johnny, on the other hand, is helping us with the live shows that are happening today after we record. So he's considered mission essential and he's at the studio today. So how's everyone been holding up with staying at home and quarantining? I know it's not for everyone. So
I've discovered how much of my anxiety has been caused by social anxiety, so I'm loving this. But it's giving me time to work on my shows. So I've got 3 shows on the books. Actually, 3 shows filmed already that I have to edit and get out there. But this is actually working really well for me.
And what's the name of your show, Jenna?
The name of my show is called Atheist Stasis, but it's on my channel, Jenna Belk, because I want to have different shows over time. But you have a show too, right?
I do, and that's what I have been kind of working on when I'm not managing. They shut the schools here until May. So now I have to add homeschooling to my list of responsibilities, which I'm learning I should have never been a teacher. Well, my show is the Atheist Wind Down, WINE. We've got 5 shows out now. The first series I did was horribly disgusting ways on how to quell your wife's sexual refusal. And this last one that I did was about evangelicals going to the Amazon to contact indigenous tribes during COVID-19 to spread the word of Jesus. So that's been super fun and angry. Johnny, how are you doing with kind of sheltering in place and not going anywhere lately except for the studio? Because
I work remotely, so it hasn't been affecting me all that much. But you get to notice those little opportunities to make contact with people, both figuratively and literally. And I think a lot of people I've been reading a lot of news articles about people struggling with the cabin fever. I've been having it, I'll be honest. Yeah. But it's for a greater cause. It's for the greater good that we just stay isolated for a time being and understand that it's not going to last forever. And we'll be back into business.
And some people are isolated together. So if you have your family, I mean, this is a great time to learn how to get along better, because families are tough.
I have learned that a lot of things that my kid is interested in, and I've been completely schooled on the operations of a Nintendo Switch, so now I feel slightly more educated.
Yeah, well, you're more involved in his life, so that's good.
Yeah, and there are ways to get involved virtually. We've been doing a lot of virtual get-togethers, kind of like this. So if you guys are kind of struggling with that, need someone to reach out to, need someone to talk to, or just some ideas on how to get involved or set up stuff, you can email us tv@atheist-community.org, bitches@atheist-community.org. I can be reached at Jen Aldrich at atheist-community.org. Jenna, what's your email?
Jenna Belk at atheist-community.org.
And yeah, you can get in touch with us and we would be more than happy to kind of guide you guys along in that direction.
If you want to send out a general email to everybody at the ACA, then you can just email tv@atheist-community.org and that'll get all of us.
Right. And we have a lot more hands on deck with that email. So you'll probably be responded to a little bit quicker and maybe have an opportunity to get different opinions and different ideas. So with that, let's jump in today. Today we're talking about the Supreme Court rulings on LGBTQIA workers' rights, which would fall under Title VII of the Civil Rights Act of 1964. In the last year, rights and protections for the LGBTQIA community have been on the line in ways that we haven't seen in a generation or two. In this episode, we're going to go over the cases that have been heard in the United States Supreme Court and the protections offered to those in the community. On their calendars are a few cases concerning the community and the same protections offered under Title VII. Most of these are dealing with work cases. But before we get into our current cases, we're going to highlight the most important case heard before the Supreme Court concerning the LGBTQIA community. And that was Obergefell, and I'm probably butchering that because my mouth just doesn't like putting that out there, versus Hodges, where groups of same-sex couples sued their relevant state agencies in Ohio, Michigan, Kentucky, and Tennessee to challenge the Constitution, saying, yes, individual states can recognize same-sex marriage, but we federally will not. And this started when, I can never say this, Obergefell.
Yeah, it looks like Obergefell to me.
Obergefell, thank you. Sued because his husband was terminally ill. And because of the federal mandate stating that we don't recognize same-sex marriages, he was not able to be the inheritance on life insurance. He couldn't be listed as next of kin, and he wouldn't have been taken care of once his husband did die. It was ruled in a 5-4 decision by SCOTUS in favor of making same-sex marriage legal across all 50 states.
Title VII is of the Civil Rights Act of 1964, and Title VII specifically deals with discrimination for employers based on race, color, religion, sex, or national origin. It doesn't apply to all employers under all circumstances. There are exceptions, and some being the type of business that it is, if it's a religious organization, a 501c3, and of course, if it's businesses of a certain size.
Right, I was going to say, I know if it's under something like 50 employees, they can bypass the Title VII Act, correct?
I think it's Title VII only applies to employers who employ 15 or more employees for 20 or more weeks in the current or preceding calendar year, and that's straight from Wikipedia.
Straight from Wikipedia.
Straight from the truth, horse's mouth. So if you've got a small bit... Oh, sorry, I was going to say,
I have a quick question.
Please.
So this Title VII of the Civil Rights Act of 1964, I did a bunch of research on just kind of the amendments because it's been since high school, really, since I'd really looked into it. And so I'm learning about how the amendments work in the Constitution, and there's clauses. So how does Title VII of a Civil Rights Act tie into that at all? Or does it?
Well, so are you talking about how does Title VII of the Civil Rights Act relate to the Constitution and to the amendments?
Yes.
Well, the Constitution is the founding document of this country, and the first, it has the provisions for setting up the general structure of the government. Some of the founding fathers found that that document didn't contain sufficient protections for individual liberties, and so they drafted what is now referred to as the Bill of Rights, the first 10 amendments of the Constitution, and then after that are additional amendments. So all laws that are passed, all federal laws that are passed, have to be compatible with the Constitution and its amendments. State laws also have to not violate any of the rights guaranteed by the Constitution or the amendments. And so the Civil Rights Act of 1964 was one of those laws to expand the protections of other individuals within our society. And so it's not an amendment to the Constitution, it's just a law. But it's a federal law that we all have to follow, or that these people have to follow.
That helps. Thank you.
Yeah.
Thank you. We've needed that on the show. So let's jump into the first case. Our first case, the first two cases we're going to be discussing is discrimination based on sexual orientation. There's a case currently in front of SCOTUS, Bostock versus Clayton, who Gerald Bostock is a gay man who was a 10-year employee with the Clayton County, Georgia Protective Child Services. I'm sorry, guys, it's early. Who was in excellent standing and had joined a gay softball league. But during a meeting where his supervisor was present, another employee made some remarks about Mr. Bostock's sexual orientation and his participation in the league. Shortly after this meeting, within weeks, Clayton County had put Mr. Bostock on alert that they were conducting an internal audit of funds that he specifically was managing. And then shortly after this audit, he was terminated for conduct unbecoming of its employees. So, yeah.
I'm curious, when we talk about conduct, and I quote, conduct unbecoming of its employees, how is that a legitimate reason to fire somebody using any kind of laws?
They can say that they found funds being mismanaged, that his supervisory or leadership position was not up to par for whatever set of standards that this specific agency has. They
So
can,
when people say up to par, I'm confused. I guess it's the company's standards?
yes, it is. It's well, this is a state agency. This is Child Protective Services, and they have a set of conduct laws and ways to manage money, conduct being you can't be unprofessional, how you handle child welfare cases.
Okay.
And because this was specifically concerning audit of funds, they can go and find something as much as a 5-cent difference in something and say, well, he's mismanaging them. We can terminate him.
If I could add something, I don't know about, now this case took place in Georgia, and I don't know what the worker-employer relationship is. In Texas, we're an at-will employment state. That may be the case in Georgia. It may not be. In Texas, you don't really have to have a reason to terminate your employment with someone, but you can't terminate your employment for someone for a bad reason.
Wait, yeah, so you don't have to have a reason, but if you do, it can't be bad. So if you have a bad reason, can't you just say you don't have a reason?
That's my understanding. If, let's say, business isn't very good, you can terminate employment, but you can't terminate someone because they're Black or gay or a woman or some other reason like that.
So it is in the law that you can't fire somebody because they're gay.
That's what we're arguing about.
That's what we're arguing, yeah.
Okay.
There's currently, they're going very back and forth. We've had some cases that have said, yes, they do fall under the protection. We've had some states say that, no, they don't. Georgia is an at-will state. But however, this is also a state agency. So state agencies have a bit more stricter guidelines as far as hiring, firing, and job protection and security. It's kind of notoriously known that if you work for the state or if you work for the government as a GS employee or a state employee, your job is pretty much all but guaranteed, and you really got to screw up in order to be.
Oh, wow.
Yeah, like I know quite a few federal workers, and I've watched some of them like not go to work for 2 weeks, show up with a doctor's note and be like, haha, like it takes a lot to fire somebody.
So this is a big deal then, because if this person was to be fired for this reason in Texas, it would not have gone to the Supreme Court, correct?
Right. This is Georgia.
Right. It's because it's a different state.
What this is saying is that now this could possibly reach to state agencies which would enact state law in Georgia. And this is why this one's so important. This isn't just an individual business where somebody can turn around and say, well, they own the business, kind of like the cake issue. Well, they own the business. They can, it's a right to work state. They can hire and fire who they want. This is a state agency. So the guidelines that are set in this case can also apply to the state itself.
Interesting.
Right.
I don't know if we're going to be getting into the application of Title VII to sexual orientation. Is that something that you were going to talk about soon, or can we talk about that? Okay.
We will be talking about that. I just want to get the rest of this case out so we can kind of find out what happened afterwards. Within a few months of his termination, Mr. Bostock filed a discrimination charge with the Equal Employment Opportunity Commission, also known as the EEOC, more commonly known as the EEOC. 3 years later, in 2016, he filed a pro se lawsuit against the county alleging discrimination based on sexual orientation in violation of Title VII. The district court dismissed the lawsuit for failure to state a claim, finding that Bostock's claim relied on an interpretation of Title VII as prohibiting discrimination on the basis of sexual orientation, contrary to a 1979 decision holding otherwise. He also continued, which was recently affirmed by Evans v. Georgia Regional Hospital, and Bostock appealed in the 11th Circuit Court that no, this clearly falls, sexual orientation clearly falls under Title VII as referenced to this case, which is common to do when filing an appeal. In noting additional procedures and deficiencies in Bostock's appeal, the 11th Circuit Court panel pointed out that if it cannot overrule a prior panel's holding in the absence of intervening Supreme Court or the 11th Circuit en banc decision. Johnny, do you want to explain what an en banc decision is, or?
Sure. An en banc decision is, let's see. An en banc is all of the judges of the court joining together and ruling together. So however many judges there are on the 11th Circuit, let's say that there are 6 or 7, en banc means all of them sitting at once. And so there'll be a panel of judges that issue rulings in usual appeals, but if it's an en banc decision, then that means all of them are going to be ruling on that particular decision, issuing that opinion, and a regular panel can't disagree with an en banc decision.
Right.
Does
And
it
if
have to be unanimous?
It does not have to be unanimous.
If I'm not mistaken, the 11th Circuit Court has over 20 judges as well. So there were quite a few judges sitting in on this procedure.
Oh, I didn't know that.
Yeah, the 11th Circuit Court has quite a lot of judges.
I gotta look into these circuits of courts. More on that later.
To kind of break down for everyone why everyone keeps seeing 11th, 9th, 12th Circuit Court. If you guys have ever watched The Hunger Games, it's actually really similar to that. We have 11 circuit courts in our nation, which are broken up by groups of states. One is like Maine and New Hampshire, and I believe Rhode Island. 11 is the southern states. And 2 is really funny because it's only New York and Vermont, which I find hilarious that there's so many coming out of that. But they're broken up in different groups of states. And when you file an appeal with your state's court, with your state Supreme Court, if you don't agree to it, you have to appeal to your circuit court. And then the circuit court who overrules these courts for so many states will then hear on it. So you're and each circuit court has a different sitting Supreme Court judge. So you're kind of at the mercy of which judge is more liberal, which judge is more conservative. I believe 11th Circuit has Ruth Bader Ginsburg. So that tends to lean a little more liberal. But if you get like Alito.
Can I chime in to this one?
Sure, absolutely.
So there's state courts in this country. Each state has their own. Texas has them. California has them. And then there's the federal courts. If you get, let's say, arrested for breaking and entering, that's a state crime. You would go before a state judge, a criminal court. You would have your trial or you would plea out, and it would go however it goes. If you don't like the outcome of it, you would appeal to an appellate court. And then if they would either affirm or deny and remand back to the original court for findings consistent with their opinion on your case. If that decision is unsatisfactory, then you can appeal to the state Supreme Court. The state Supreme Court can choose to take your case if it's significant enough, if they believe that there's a disagreement among the lower courts on how to apply a certain provision of law. And then in the event that you're not satisfied with that decision, you can file a petition for certiorari to go to the U.S. Supreme Court for those really big society-changing decisions. That's one way to get to the Supreme Court. The other one is to have a federal issue that you have to do. You go through the federal court system. So you would have a federal district court. We have one in Austin, and you have your proceeding there. That gets appealed to the Fifth Circuit Court of Appeals, which sits in New Orleans, but occasionally they'll come to Houston and they'll hear arguments there. And based on that decision, a party may appeal similarly, and the court to the U.S. Supreme Court. The U.S. Supreme Court can choose to take that case. So it's two parallel systems that have some interaction together, but generally they're fairly separate. So I don't know if that clarifies it at all.
It does, actually.
Okay.
That helps me a lot.
Another thing to note, this defendant was pro se. And what pro se means is you defend yourself. That's a fancy way of saying you're on your own. Coming up against the federal court system is confusing. It's intimidating. And it's kind of, this takes going through years of case law, 50 years of the Civil Rights Act. It's kind of no wonder that Mr. Bostock maybe have missed a few things because of this. But it's kind of, hey, when somebody tells you need a lawyer, get a lawyer. Like, hey, don't go. What is it they say, Johnny? A lawyer who defends himself has a fool for a client.
Yeah.
Not everyone can afford a lawyer.
But
No,
it's,
they
you know,
can't.
this is right, and this is also Georgia, so he may have had a hard time finding somebody, finding a lawyer.
Well, and I know somebody who can't afford a lawyer, and for some reason they weren't approved for a court-appointed lawyer.
Right,
That's right.
I can't remember, the Legal Aid Society is income-based, and
Mhm.
it's in the lower end of the poverty range, so
Low.
low end of the poverty range, so if you're higher low-wage earner to middle-class wage earner, you're not gonna qualify for a legal aid society coming to help you, which puts a huge chunk of this population at risk of being unrepresented because lawyers are not cheap. My divorce alone cost me over $10,000, and that
Yeah.
was loans
So
and borrowing money and everything else, so
mhm. I
I
think that
could
we'll
not
have to
afford
have a
my own.
whole nother episode on that.
yeah, but it's, you know, this case is highlighting specifically sexual orientation at a state level, which is really scary because if they can turn around and say, well, the state fired him because he was not protected under Title VII for employment protections, that means that any state that decides, hey, we don't want to employ gay people can start firing people and start putting it in their state guidelines that we can fire on the basis of sexual orientation. Looking and living in the South, this is terrifying because no matter how much they want to ban gay people and pray the gay away, gay people still exist and need to pay bills
Yeah,
is the issue.
and everyone's afraid to come out because of stuff like this.
Right, and then you do have, you know, when you do send for references, if they are fired, especially if they wanna go to a private company, they call the old boss for references and say, "Well, why did you terminate this person?" They can turn around and say that they were so flamboyantly homosexual that it was creating a distraction in the workplace, that they can make up pretty much anything.
Actually, I thought that they can't do that. I thought that all that they can say is, "Would you rehire this person?" And they have to say yes or no.
They can ask on job performance too, especially if it's a case like this where it was, quote, unquote, "found" that he was mishandling funds. They can ask
Mm.
because
Well,
it's considered fraud.
that's the likely thing that would happen no matter what this decision um, results in, whatever the opinion says. Is I think we can all agree that if somebody is fired for an improper reason, or a reason that might be difficult, or what's the word I'm looking for? Controversial. They're going to find a reason to fire them. When I see in the notes here, conduct unbecoming of its employees, right? This is in the context of conducting an internal audit of funds that he was managing. So that's always going to be where they go. Although in a case that we're going to talk about later, that wasn't the case. It was
That wasn't right.
expressly because the person was transgender. But yeah, you're not being fired because you're gay. You're not being fired because you're black. You're being fired because you were difficult to work with.
Because we found 5 cents that was mismanaged.
Yeah,
I see.
some
Right,
legitimate reason will be held up as a pretext.
Right, they can even say that your personal if in to kind of shade being gay, your personal life had interfered with your job performance too much, or it made the work environment uncomfortable is what they can also say. So if, say, Mr. Bostock brought his boyfriend or his husband to work, kissed him goodbye, maybe had his boyfriend or his husband drop him off lunch. If enough people were uncomfortable with a gay couple being in the office, they can turn around and say that his personal life was creating an uncomfortable work environment.
They
Or
need to
his
go hang out with more gay people.
These people won't though. But this is a very slippery slope that if we blanket conduct unbecoming can be set for
Right.
anything with an employer. Conduct unbecoming could be I'm wearing a crop shirt right now. Conduct unbecoming could be she wore a crop shirt. Her, you know, she was her clothes were too tight or anything like that because it's creating an improper and uncomfortable work environment was what I wanted to quote.
Mhm.
So this is an extremely slippery slope, especially when it comes down to a state agency because, well, this state agency did it, so the next state agency can, the next state agency can. And when somebody else who's from another state, they can then reference this case and say, but this was the judgment in this one, so there's a precedent.
Well,
So
if
what
it were,
became before this? What are they referencing?
Evans versus Georgia Regional Hospital, which give me a second, I will pull up here because I was not prepared because it's weird doing this from home. It is weird a little bit doing this from home, ladies and gentlemen.
Jen, while you're looking that up, could I just say one more thing about that?
Absolutely.
You had said how, let's say, so where this is in Georgia, and let's say this case goes against Mr. Bostock, right? And the Supreme Court rules that a state can, well, it does have precedent because, let's say a state can discriminate based upon sexual orientation under Title VII specifically. Because the Supreme Court made the ruling, then it would have a precedent across the country, depending on how narrowly they issued their opinion. It can be narrowly tailored to the specific facts of this case, right? If the decision were solely in Georgia, it would only apply within Georgia, and other courts could look at that decision and could use it as persuasive authority. So let's say it only got to the Court of Appeals in Georgia. This is probably the reason why the Supreme Court took it, because they're looking at different rulings by different courts of appeals, different district courts are all looking at this differently. And the Supreme Court said, there's differences between the circuits. The courts need guidance. We're going to weigh in. Now, there's lots of different ways that a court can write an opinion, like I said, narrowly tailor that opinion to just the narrowest facts possible. They can broaden it very broadly and make it apply to a lot of different scenarios. So it remains to be seen how they're going to narrow this opinion, or whether it's going to be broadly sweeping.
Yeah. And we'll cover later on the process of the Supreme Court and when we should expect a ruling. In Evans v. Georgia Regional Hospital, it was filed in 2017. The plaintiff filed suit against her employer, alleging that she was discriminated against because of her sexual orientation and gender nonconformity, and retaliated against after she lodged a complaint with her employer's human resource department for backlash because of this. The district court dismissed her pro se complaint, again pro se. The court held that discrimination based on failure to conform to a gender stereotype was sex-based discrimination. And in this case, a gender nonconformity claim was not just another way to claim discrimination based on sexual orientation, but instead it constituted a separate, distinct avenue for relief under Title VII. The court vacated the portion of the district's court order dismissing the plaintiff's gender nonconformity claim with prejudice and remand with instructions to grant the plaintiff leave to amend such claim. We're going to have Johnny clear that up here in a second. The court concluded that the binding precedent, Blum v. Oil Corporation, yet another case because this is what happens, foreclosed the plaintiff's argument that she had stated the claim under Title VII by alleging she endured workplace discrimination because of her sexual orientation. The Blum court held that the discharge for homosexuality was not prohibited by Title VII. Therefore, the court affirmed a portion of the district's court order dismissing the plaintiff's sexual orientation claim. Finally, the court considered any challenge to the district's treatment of the plaintiff's retaliation claim as waived. So this is stating that, and if I'm reading this wrong, Johnny, please clear this up for me, that under her gender nonconformity claim was valid, but her sexual orientation claim was not.
I'd have to look more carefully at that case in order to give you an opinion that I'm comfortable issuing.
Right.
But there are a lot of procedural procedural hurdles that a petitioner needs to overcome when they bring a claim in court. To speak to your earlier point about how the federal courts can be an intimidating place for pro se litigants, I think that's true. However, if I were a pro se litigant, I would prefer to be in federal court than to be in state court, because the rules are very, very clearly laid out. I have gone up against, in my practice over the years, a lot of pro se litigants. I've found that they were treated more fairly, given more, I don't want to say more fairly, that's unfair to the judges of the state of Texas, who I do believe on the whole want to hear the evidence and critically evaluate the claims under the law. But I would say that the federal claims got a bit more mileage out of them, just because the judges had an interest in making sure that the entire claim was heard on the merits insofar as it could be. And so if the claim had a procedural infirmity, you might say, and the court identified that at the appellate level, it wouldn't be unheard of to remand it to the lower court to give the petitioner, the pro se litigant, the opportunity to fix that. So that's how the courts are structured to meet the ends of justice. It just doesn't always get there. But that would be the way to go about it. It's not up to the appellate court to fix it. It's up to send it back, remand it back to the trial court level for additional pleadings consistent with the appellate court's decision on a particular issue. So that's a protection for the litigant.
Wow.
In that sense.
And what I did notice here is that this is another Georgia case that went pro se. So
Right.
I'm now starting to wonder if lawyers in Georgia will not touch Title VII civil rights cases.
It may have been that the client did not have enough money.
That could be it too, and that's.
And if
Yeah,
I
we're going
might
to
say-
address that on another episode.
Let me say one thing about that, okay?
Sure.
It seems heartless on the part of the attorneys without knowing more about this case, okay?
Right.
We're not looking at the facts. We don't know what the actual Mr. Bostock was like or what Evans was, what their scenario is. But the fact that an attorney might not take your case does not mean that the attorney believes that your case has no merit.
Right.
Attorneys, like everyone else, have bills to pay.
Right.
It's not something that we can do for free because our time is expensive, because our costs are expensive, and the practice itself is expensive.
And the time itself it takes to research cases and get cases together is
Right.
lengthy. This isn't something that you can just kind of slap
Well,
together.
see, right now, we're creating a show where we're trying to basically interpret all this stuff for the general public. This is difficult. This is complicated, and it takes time. And there's all these terms you have to learn, and all this. It sounds like it's just like this spider web of you can do this, but you can't. But if you do this way, then it's like whoa. So I appreciate people that do go into this field and try to make any kind of difference, because that's a huge task, especially when you're such a minority.
Every lawyer I know works well after office hours,
Yeah.
7 days a week. Everyone that I know.
I went to school for 3 years to study how to generally do this job. And when I came out, I didn't know how to do shit.
Mhm.
And
I love that.
it's
Spend all
true.
your money and not know how to do a goddamn thing when you.
I have a girlfriend that's a lawyer, and she's bartending.
Mhm.
Yeah.
So
Yeah.
to get back to the Supreme Court, sorry, can y'all hear me? It sounds like I'm blowing a lot of air into this.
No, you're
I can hear you.
Okay.
You're blowing a lot of air into that now.
Sorry. Anyway, I'm sorry. I'm just confused. I don't know what to do, because there's no way to prove that these things actually happened. It's like it's so complicated, and some people are lying.
It is. And this is why everybody always says, if you are facing any form of discrimination, if you are facing any form of retaliation, document. A lot of states are what are considered one-party consent, which means that as long as you are a party and consenting to being recorded, you can be. Some states are two-party. You have to tell the other person that they're being recorded.
Mm-hmm.
Whoa.
Yeah. There are some states are one party. I know here in Tennessee, I don't have to tell the other person they're being recorded as long as I speak. It's fine. Same thing with Texas. As long as I speak on whatever recording, I'm considered one of the parties and fine. But New York is a two-party state. So you have to actually expressly tell them this is being recorded or this call is being recorded. Do you consent?
Wow.
Before they, right. Document. We live in a digital age. People tend to slip and think that they're protected digitally. They feel very safe behind a screen. And I'll probably do a lot of discrimination in that avenue. Document. So this way it doesn't become a he said, she said. No, this isn't what I meant by it.
Right.
No,
Like,
it wasn't said. Right.
like if somebody tells you something that's derogatory, write down the date and what was said and who it was, and then just keep going about your day. When it gets bad enough that you have had enough, that's when you can go to HR and say, I have all of this evidence. I don't know what to do. Help me.
Right.
I'm not recommending on a specific case, but I would say if somebody says something inappropriate to you, a lot of the complaints that we've heard in the media lately from these Me Too guys is, well, I just don't know what I'm supposed to do. It's so hard to be a man in the 21st century, even though we have countless examples of what it's like to be a responsible, decent human being, both from people we know and in media. And your sense of look at people's faces. Are they making a nasty face? Do they look uncomfortable? Then you're an asshole. Stop doing that.
If somebody say no, then that means no.
But if something does happen to you and you work in a company that has an HR department, there's ways to address these things. You don't have to go into the HR department and demand instant action. But I think it's important to, as you're recording these instances, bring it up to your HR manager and say, hey, I this happened today. I don't know if I misinterpreted it, but this is what was said, and I just want to bring this to the attention to the HR person. In my experience, what I've seen is they'll say, they want to know that you've tried to resolve it on a human level, right?
I'm sorry. Go ahead.
And so it doesn't have to become a big thing in the beginning, but it needs to be a thing. Whether it's you talk to Joe in accounting and say, hey, don't talk about that around me. I don't want to hear it. Okay, please. I like you, or you don't even have to say that if you don't like them. But I feel uncomfortable, and if Joe's a jerk, then Joe's going to make a big deal about it and say that you are a hypersensitive snowflake, whatever they might be. But that's not him.
If you don't give them the opportunity to learn that it's making you uncomfortable, then that's not really fair.
Right. And I would also not advise on bulk getting your evidence and then dumping it all at once. Document it every time it happens, because then it shows pattern. It shows pattern, and it also shows that you went to correct the issue immediately. You weren't just sitting on it. It doesn't look retaliatory. Every time something happens and you have documentation of it, report it. Every time.
There may be many instances where people of good conscience say something inappropriate.
Right.
And just
we've all been guilty of that.
Diarrhea came out of their mouth and something was bad, right? Not a good thing, inexcusable, and yet there's ways of dealing it in a way where we can all still work together and get together. And maybe that person that was the tipping point. I've done and said things in my life, and not necessarily gross Me Too stuff, but like, you're right.
Yeah, like,
sorry.
Especially. And I've noticed this especially with the millennial shift. The millennial cut is what I call it. Like people who were adults during 9/11 and people who were teenagers and children during 9/11. Man, you younger guys have it on lock. And some of us still have that older kind of way that we had grown up. And it's still kind of there. And we don't want it to be there, but it slips. So we're kind of counting on, the younger generation to be like, don't do that. Don't do that. And if you tell somebody, hey, that's not cool, I'm not comfortable with it, and they're like, I'm sorry, and it never happens again, then fine. But if it happens again, that's when you go to HR. That's when you go to report it and say, hey, I've expressed this. They're making me super uncomfortable. They're being super unprofessional. This needs to be an issue, but document it every time.
I don't think that it's really a generational thing. I think everybody should do that.
Absolutely. Yeah. But what I'm saying is the older end of millennials tend to not be as aware of it a lot of the time than the younger end is. Because
maybe we should ask the older people to try to be more aware.
We're trying.
Yes.
I know. And I used to wait tables in bars and restaurants. And so I have had plenty of experiences with sexual harassment, all of that. Everybody that I know pretty much has. But when it happens, typically we don't do anything about it.
All right.
Because it happens so often that we're like, well, why am I special that I'm going to get something done now? But my best friend yesterday, you know? So it's hard because it's completely against our culture right now to report stuff like that
Mhm.
because it's embarrassing. It's private. It's so many people are so quick to judge. So also the other person that did that, you may say, "Oh, well, they're a good person. They didn't,
Mm.
I like them. I don't want to hurt their feelings." And so it's just so complicated.
Yeah.
It really is, and we're gonna be getting more into how to report, how to go about this later in the episode. I don't wanna get too far off the rails here.
Yeah.
So let's start covering our second case. Our second case is Altitude Express versus Zarda. Now, this is being combined with the Bostock case, which commonly happens within the Supreme Court because the Supreme Court will only hear a certain amount of cases per year. They get a whole calendar, and then they kind of pick and choose which ones they want. So when they find cases that are similar to each other, they tend to combine them so that we can encompass all different ends of what's being heard and kind of blanket rule, okay, all of this will fall under Title VII. So this is pretty common when you find cases that are combined within the Supreme Court. In Altitude Express versus Zarda, excuse me, worked in 2010 as a skydiving instructor with this company. And part of his job was to participate in tandem skydives with clients. And tandem skydives are, if you
Awesome.
Jenna's done one. If you are going skydiving, you're inexperienced, they strap an instructor to you so that you don't die, pretty much.
Very closely.
Right, and he was strapped insanely closely to these clients,
Mhm.
and Zarda is a gay man, sometimes told female clients about his sexual orientation to address any concern that they might have about being strapped to a man for a tandem skydive. On one occasion, after Zarda informed a female client about his sexual orientation and performed the tandem jump with her, the client alleged that Zarda had inappropriately touched her and disclosed his sexual orientation to excuse his behavior. In response to that claim, Zarda's boss fired him. Zarda denied touching the client inappropriately and claimed that he was fired solely because of his reference to his sexual orientation. He then filed a discrimination charge with the EEOC, claiming that he was fired because of his sexual orientation and also because he did not conform to male gender stereotypes. He brought a claim in the federal court alleging, among other things, that Altitude Express violated Title VII by terminating him because of his sexual orientation. The district court ruled for his company, finding that Title VII does not protect against discrimination based on sexual orientation. And after the court's ruling, the EEOC issued an opinion in a separate case, persuasive, but it's not binding in federal courts, that Title VII's on the basis of sex language includes in discrimination on the basis of sexual orientation. In light of this decision, Zara moved for the district court to reinstate his Title VII claim, but the district court denied the motion, citing binding Second Circuit precedent in the Symington v. Runyon case and Dawson v. Bumble and Bumble. Zarda then appealed to the U.S. Court of Appeals for the Second Circuit, which ruled for Altitude Express as well. The panel declined Zarda's request that to reconsider the Title VII interpretation in Symington and Dawson, as only the court sitting en banc to do all that. Again, we're having more en banc decisions being made here. And it's consistent with the EEOC's position that Title VII's prohibition on discrimination based on sex necessarily includes discrimination because of sexual orientation. So we have two other cases here. Symington versus Runyon was, again, based on sexual discrimination, and it was overturned by the entire court sitting en banc, actually. I believe they
Wait, are we still talking about the same case?
yes, these are the cases that was used to cite and reference Zarda.
Oh, I see.
Right. Simonton sued Postmaster General in the United States Postal Service, which is why this is so huge, because this is a federal organization, for abuse and harassment he suffered by reason of his sexual orientation. If I'm not mistaken, they ruled in favor of Symington and then overturned it, which was scary. Bumble and Bumble. The Bumble and Bumble case I found kind of interesting because I used to get my hair done at Bumble and Bumble, and I used to get my hair done at the same salon that they sued. So what this person was claiming was that she was fired on the basis of sexual orientation and that crude comments were made. Now, like I said, I've sat in that chair and this was in a very liberal area. And I had never once ever even sitting there had heard any kind of discrimination or anything considering sexual orientation. And I've had friends, I myself have brought same-sex partners into the salon with me, and there was never a problem. So when they kind of ruled in favor of Bumble and Bumble, I was like, yeah, okay. Like this really sounds like a just angry salon worker who was like, well, it's because I'm gay. And I'm like, well, sweetheart, I'm queer. And nobody said a damn thing to me. They still took my money. But in cement,
Well,
like,
hmm.
but I'd also known other stylists that had worked in other Bumble and Bumbles who were queer, who were gay, that had never had a problem as well. So this may be why the Supreme Court is so hesitant to rule on cases based on sexual orientation, because they're afraid of the floodgates opening. And we may have just really shitty workers turning around and saying, hey, I'm gay, hey, I'm queer, and this is why they fired me.
It may also be a matter of,
because there's a precedent with the Bumble and Bumble case with that.
in some of the other cases, I don't know which one it was, but one of the arguments was that there is an interest in allowing the states to exercise or to provide guidance for the EEOC. Can't remember which one this was, but once the Supreme Court issues a ruling, the entire country is, depending upon the ruling, is bound by it. There is an interest in allowing the different states and the different circuits and the state legislatures and the U.S. Congress to provide additional guidance through a public process of representatives, congresspeople voting and adding additional provisions. When the court does something, this tends to be you might say a conservative argument. I've heard this conservative argument, especially in Obergefell versus Hodges, where the Supreme Court is kind of like an aristocracy. It's only so many people, and they are appointed for life, and they issue these rulings that have broad, sweeping effect upon the entire country. And I think on the whole, the Supreme Court is hesitant to make these decisions because there is a public process of the U.S. Congress where we all get to vote for our senators and congresspeople. Those people can then vote for amendments to different laws to add language like sexual orientation is included in sex. Right? Or sexual orientation shall not be included in sex because of this. They might have an express provision excluding it. And the benefit to that is if this is what the people want and it's consistent with the protections that the Constitution guarantees and what this statute spirit, as nebulous of a concept as that might be, was drafted, then let's let the public decide that. That was some of the argument in Obergefell versus Hodges. And when I read it, and I'll be honest, I read it in anticipation of reading a portion of the opinion for a friend of mine's same-sex marriage. In lieu of a prayer, a good friend of mine, wanted me to read from that opinion, which I thought was beautifully written. But as I was reading it, for the beautiful parts, extolling the virtues of marriage, and extolling the virtues of same-sex marriage as being equal to and not in any way different in any real important qualitative way from opposite-sex marriage, that there was an argument that there was a wellspring, is that the word, of support for same-sex marriage constitutional provisions across the United States at the time, and that the tide was turning in favor of the states issuing their new laws on this, and that this was coming from the ground up, and that rather than making a decision from the top down, we should allow this to continue. Now, of course, if you are a same-sex person who wants to get married and you live in Alabama, it might be a 30-year wait, or never. But on the other hand, and this is, I think, the conservative argument, the states have individual. So the Constitution says one of the oh gosh, I think it's the 10th, but I'm not sure if it's the 10th right now.
See, this is how confusing the Constitution is. The constitutional law person forgets which amendment.
I know.
I haven't had to deal with this in a little bit of time, but there's an amendment that says all of the rights that are expressly provided for by the Constitution and the amendments are given to the federal government. Anything that isn't expressly given to the federal government is reserved for the states.
Correct.
Okay.
Correct.
And whatever, I think that's the 10th, but if I'm not, sue me.
Well, go ahead, Johnny. You actually did touch on something about it coming from higher. And this is what some of our Supreme Court judges are actually saying. Justice Gorsuch, I should say, I'm sorry, who is a textualist and is usually very conservative. So this is why we're getting a little worried. Judge Gorsuch loves going on the text of the Constitution, loves going on specifically the text of the actual titles in the Civil Rights Act, and based on his interpretation of the text, which sounds a little Bible-y to me, but okay. But this is what we're worried about with this. And he, like I said, he's a textualist in the dismissal of the cases and holding one case up against the other. However, Gorsuch has repeatedly suggested that the words of Title VII may well bar employment discrimination based on sexual orientation and transgender status. The question was, he said, really, really, really close, which is really surprising because he's just so conservative. So we weren't expecting Gorsuch to be like, no, actually looking at the text in this, no, like, it bars discrimination, which, slack-jawed everyone. However, he was, this makes me crack up. He is concerned about the massive social upheaval that would follow from a Supreme Court ruling saying so. Such a significant change, he mused, may be more appropriate coming from Congress rather than the courts. So he's not saying it should bar discrimination. He's saying, hey, the text is actually reading this way. However, once we do this, just all the gay people are going to come sue the Supreme Court and want all their, all the gay cases in the Supreme Court. It's going to be a massive social upheaval and just society's going to break down. So
if you really think that's going to happen, why don't you just agree that there are LGBTQIA people out there?
But what he's now saying is, instead of it leaving up to the interpretation of Supreme Court justices, that Congress needs to enact bills and laws and vote on these and have the president either veto or accept them and have Congress go through them in order to just set like a blanket precedent. And I'm like, wait, dude, no. Your job is to hear cases that come down on titles and amendment. Like, do your fucking job. Do your fucking job. Stop scapegoating this shit.
I think I understand the concern. I don't know where I fall on that. I consider myself a liberal progressive chap, but there is value in allowing Congress to make these big societal changes. There's value in it.
Hold on. What would it mean if it goes to Congress versus Senate differently?
Oh, the Senate and the House of Representatives would act together. The Senate and the House of Representatives together is Congress.
Right.
Yeah.
So what would have to happen is somebody would have to draw up a bill. It would have to go to the president. The president.
What kind of bill?
It's
that we had an Equal Rights Act already.
That's an act amended to something. They have to draw up an actual law and bill.
Okay, can I chime in?
Wait, I may be wrong in that. Please,
right.
Johnny, clear. This is why we have you here today. Thank you.
I don't want to mansplain this one.
Oh,
no.
That's another episode. We'll have you back on for that.
I asked.
Oh, please. Shoot. No. So the Equal Rights Amendment wasn't ratified by all the states, right?
Yes.
So that's a different conversation altogether. I need to brush up on all of that stuff. And you're not asking that, I don't think. But
not yet.
No. So the Civil Rights Act, 1964, it's had all kinds of amendments throughout time. So someone would have to propose an amendment to that particular act, right? Adding language. And anyone can go online in Texas or in any of the other states or in the federal system and look up changes to bills that propose to change the language. So what it'll look like is you'll see a bill is proposed is brought forth in the House or brought forth in the Senate, and the House will usually assign a committee or a subcommittee to review the merits of that particular bill, and they'll vote on whether it gets to be heard in the House or the Senate, and then the House or the Senate votes for it, and then it gets passed to the other side, to the House or the Senate, the other one. So if it started in the House, it'll go to the Senate. If it started in the Senate, it'll go to the House. Mm-hmm. And they have to get a majority of those folks to approve it. So when you look at those bills, what they'll have is they'll have the original text of the law, and then there'll be little lines like strike-throughs or something like that, showing what they're changing.
Marks on the end, like we're changing.
Like track
when
changes.
I was looking all this up, I found the 14th Amendment in the Equal Protection Clause, and I quote, it says that it forbids any state to deny any person within its jurisdiction the equal protection of the laws.
But it doesn't say
how does that not
why.
cover.
It doesn't say why. And this is where we're coming down to the textualist. It just says, okay, any person can get equal protection of any law. But now we have to break it down.
Every single word in that sentence is a term of art. That's what we say. Yes, every single word has been litigated.
It's been litigated, yes. So it's, well, we're giving protection to this person, but this person's different than all the other people.
What protection is due?
And what does any person mean?
You have to remember, too, that we had to argue that Black people were people.
Oh, my God, yeah.
We had to argue that women were people as well. So it comes down to these very specific kind of loopholes and nuances. And also when it comes down to a bill, bills can get tied up for years and years and years and years because they're at mercy of the president. The president can veto a bill, and then it has to go back and be voted on again. And then they make changes to this bill to see if the president will approve it then. And then if he does, he can veto it again. And then we go back and forth and back and forth and back and forth and back and forth. Mm-hmm. With the Supreme Court ruling, they have to make their decision by the end of the calendar year. This decision has to be made by the end of the calendar year, and we have to vote on this at that point in time. So it's a little more expedited. But it's also weighing out. Granted, we have a heavier conservative lean on the Supreme Court, but we do have liberal justices included in the Supreme Court. So this isn't at the mercy of a conservative House. This isn't at the mercy of a conservative Senate. This isn't at the mercy of a conservative president. We have a little bit more equal balance when it comes down to it.
Although, like we said before, they have a limited amount of time to make this decision. Right. They don't look at the widespread effects. They try to, but they don't have the resources or the time or the focus to look at how this will affect the broad aspects of society. Congress can. And can take that time. They can tie something up for years, and there's a lot more people voting on it. So there's a better chance that, people can call your congressperson, call your senator, say you want Ted Cruz to vote in favor of X, Y, and Z.
I thought you were going to say you want Ted Cruz, and I was like, oh, a lot of angry comments from a lot of our fans over that one. Okay.
But you're not going to.
How do I call my congressman?
Look him up
his
online.
number's in the phone book, and I can just call him. Like he's.
You can Google who your congressman is for your district. Call their office. Usually, it's a rep. You probably won't get the actual congressman on the phone, but it's a rep that will record your conversation and record your thoughts and your opinions and how you want them to sway their vote. They will actually record these. You can organize.
What do they do with them? What do they do with them?
They pass them along to the congressman and say, hey, we're getting a lot of phone calls that this is what our people want. And this is how, they voted you in. This is how a congressman is supposed to work. They're supposed to listen to their constituents. This is the people that have voted them in and kind of say, okay, this is what my people want me to vote for. I'm going to vote this way.
Okay.
Unfortunately, that doesn't happen all the time.
And fortunately, it doesn't happen all the time, too. Because you might have instances where the people are calling about terrible things. And the congressperson or the senator is a person of good conscience and says, this is wrong or this is illegal. I'm
Right,
not going
and
to do that, and I'm going to risk not getting reelected.
we can kind of point towards slavery, which I'm sure the southern states were like, no, you need to, we need to make sure that slavery is in and here, and or even when the Civil Rights Act was first being introduced, I'm sure there was a large portion of the southern population that was saying, no, we don't want the Civil Rights Act. We want things to remain the way that they are. And the congressmen that have voted for it were acting in the better judgment of the overall society, the overall people of the United States, rather than some small pockets of constituents. However, the basis of your congressman is they are supposed to vote in favor of the people that they were chosen to represent.
Okay. They're
Right.
not supposed to vote off of their conscience.
No.
So Ted Cruz isn't supposed to use his religion to vote for anything. The fact that he's a conservative.
Well, and
Correct?
the way that they look at it is, if this congressman was voted in, clearly the conservative is the majority of this area, and this is who they want representing them. So he probably does agree with a lot of what his constituents are going to vote for. However, the Establishment Act, religion should not come into play. Yes.
So, okay. So I've learned a lot about how the courts work and how everything goes down. I have so many friends that don't vote because they're convinced that this system just doesn't work.
Mhm. And we will get
How can we convince them that it does?
we'll get into that at the end of this episode and why it is important to vote, especially in Supreme Court cases.
Well, but I don't think it's just voting.
No, it's not.
It's not, but I'm going to address why it's important to vote, why it's important to get out there at the end of the episode, especially when it comes down to Supreme Court justices in the cases. So, yeah, we will be covering that, everyone.
Can I say something and follow up to Jenna's comment?
Sure.
It's not just voting. I used to work in a courthouse, and I worked with a wonderful woman who I reached out recently, and we had a nice conversation, and I miss her and she misses me, and we had a good time. Just old times. And I remember having a conversation once about same-sex marriage, years before Obergefell versus Hodges, when it was still being discussed and various states were passing same-sex recognition acts, whatever the term for that is. Mm-hmm. And she said, well, marriage is between a man and a woman, and I just don't see why they can't just be happy with civil unions. And she meant it in not in a hateful way, just she hadn't considered it on that level before. And there was a guy, I'm going to just call him Joe. And I said, well, Joe here in the courthouse? Yeah. And you like Joe? Yeah. And he's got a partner he's been with for 20 years. Yeah. Mm-hmm. And don't you like his partner, don't you? Yes. And they love each other and they care for each other. And if they're sick and if they're such and such, you want them to be with each other and taking care of each other for the rest of their life, or as long as they want to be together. No different from you and your husband. And I really tried to personalize it so that she could understand that these gays are not so different from her and her husband and the people that she cares about. Right. And having conversations with people, not arguments, right. not angry contests of ideology necessarily, but a conversation where you try to personalize it, and then that person thinks a little differently when it comes time for them to vote.
We're going to be discussing cases based on gender identity. Amy Stevens worked as a funeral director for RG and GR Harris Funeral Homes, which is a closely held for-profit corporation that operates several funeral homes in Michigan. So it's like a chain of funeral homes. For most of her employment, she lived as a man, and shortly after she informed the funeral home owner and operator that she intended to transition from male to female, she was fired. She filed a complaint with the EEOC alleging that she had been terminated based on unlawful sex discrimination. And after conducting their investigation, the EEOC brought a lawsuit. The Equal Employment Opportunity Commission themselves brought a lawsuit against the funeral home, charging that it had violated Title VII of the Civil Rights Act of 1964 by terminating her employment on the basis of her transgender or transitioning status and her refusal to conform to sex-based stereotypes. The district court granted a summary judgment to the funeral home, and a panel of the U.S. Court of Appeals for the Sixth Circuit reversed it, holding that the funeral home's termination of the termination of her transgender status constituted sex discrimination in violation of Title VII.
Okay, what's summary judgment?
Okay, Johnny.
Thank you.
Take it away, Johnny.
I was trying to explain this to somebody recently. A motion for summary judgment is a motion that a party files, the plaintiff or the defendant, and it says something like this. Even if we take all of the facts asserted by the other side as true, with the law as it is and with the facts that are not in contest, like evidence and testimony, things like that, we still win. We don't need the jury to hear this. We win as a matter of law.
Wow.
As a litigating attorney, for the most part, it's the biggest document that I will draft in the main course of my practice. Now, there are other things that I might draft that will require as much effort. Appeals take a bit more time as well, more digging into the law, but a motion for summary judgment is a marshaling of the law and a marshaling of the evidence, presenting it to the court and saying, they can't win, here's why, we win. And the other side will file a response in opposition, and then I would file a reply, and then you'd have a hearing in front of the judge, no jury, and the judge will issue a ruling. A lot of times the other side will file their own motion for summary judgment, a competing one, and then I would file my response in opposition, and they would file their reply to my response. And so the judge will hear everything at once. It's kind of a big deal. It's a lot of fun, to be honest.
It sounds like a really strange tennis match.
Yeah, it
So
is.
it kind of sounds like there's a whole bunch of problems with the terminology in this clause. And they're saying, sex doesn't cover any kind of queer past that, anything.
Mm-hmm.
And we're saying, yes, it does.
Mm-hmm.
So when you say that what did you call it? Artistic words or something?
Terms of art.
Terms of art. Why haven't we done that with this part? Why haven't we clarified this yet?
The political process. There's no political will to either to define it one way or the other.
Why? Why isn't this creating a will to change the way that it's wording? Because it's the wording that we're arguing over.
I think the will is generating right now. This is what I think is wonderful in these terrible times, is I think the world's getting to be a better place on the whole. I'm just Pollyanna.
So you think you see progress, you see improvement, you don't see, oh my God, these people are fighting and they're winning?
100 years ago, we didn't have any transgender lawsuits before the Supreme Court.
And
Now
also
that's
we're
true.
arguing this is what we're doing right now with Title VII is we're arguing the text of Title VII to say we need this to be clarified more to make sure that there are more people falling under the protection of this and not just who we pick and choose 50 years ago.
So then wasn't that judge right that it should go before Congress?
It can. And some people do hold that it should. Some people really do hold that it should. But because of the way that our laws are based, this has to go to the Supreme Court first and say, hey, I felt they violated federal law. We got to set the precedent. And then Congress can be like, hey, this is kind of a problem. Let's draft up some bills.
Congress could chime in right now.
They could.
But but they're not.
There's no political will to do so. They're probably also at home trying to avoid the coronavirus. But we have examples of great instances where the Supreme Court weighed in on a societal issue, like Brown versus Board of Education.
Jim Crow
Yes.
law.
But in this case, was it this case or was it a different one where they cite, was it Dred Scott or an early decision? There have been examples in Supreme Court history where the Supreme Court has chimed in on big societal issues, slavery, race relations, things like that, and they've got it dead wrong. Dred Scott was one of those terrible decisions where an escaped slave was returned to
Right.
his
I
slave
also want
master.
to say that SCOTUS intervened for Jim Crow laws as well when it came down to the after slavery era, and they were for Jim Crow laws. And we're like, no, this is how it's being interpreted, which has since now been reversed, clearly. But, the Supreme Court, yes, they have stepped in on civil issues that probably Congress should have, but Congress didn't want to get off their ass to do it. So somebody had to go sue, and now it fell into their hands.
If you want to read sorry, Jen.
No. And this is kind of where it comes into play is the Supreme Court has to follow the text of the law. They have to follow the interpretation of the Constitution and the laws within it to where Congress can listen to their constituents. Now, this can go both ways. When it comes down to Title VII, we can clearly turn around and say, hey, based on this text, yes, this can include sex-based, gender-based, discrimination. And a more conservative congressman can say, but this is not what my constituents want.
Mm-hmm. Yeah.
But I guess looking at the last 100 years, it does look like, I guess we are progressing.
We're progressing, not because, but it's not because it's
it's not because what?
It's not because of a natural progress of society. It's because people are hacking away at the bullshit and doing so effectively, not just in ways that make them feel good, but in ways that actually make change happen. I wholly support people. I don't know what's effective. Don't ask me what's effective, but I can tell you that vandalizing things and attacking people may be less effective than a sustained, concerted effort to change the law and to change society, boycotts.
Actually, when people do get violent and do all that crazy stuff, that can be quite inspirational to the people trying to change things, because emotion can be an extremely awesome motivator.
Right.
It can be. It can be, yeah.
There is something interesting to note in this case, though. The Michigan District Court granted a summary judgment to their employer, which Johnny had covered earlier. But such a judgment may be issued on the merits of the case or on discrete issues in the case. In a different twist from our last two cases, the Sixth Court reversed that decision, finding that Ms. Stevens was in fact discriminated against based on gender identity and was terminated due to her gender identity. So this is now the employer bringing it to and saying, hey, but this lower court said that we were in the right, and then the circuit court said that we were in the wrong. So now we're kind of asking the Supreme Court to play tiebreaker. And this is where it comes down to state courts versus federal law. This is the issues that were kind of, this state said one thing, then the higher court said another, and now what do we do? So now we kind of need the Supreme Court to step in and say, okay, we're going to make this blanket ruling so that this is upheld federally and has to blanket.
So, but once we elect our Senate, there's nothing else that we can do to influence the Senate.
They want to be reelected.
Yeah, they want to be reelected.
How often are they reelected?
Every 6 years, I want to say.
Yeah.
Every 6 years. And is there some kind of major announcement when that happens? Because I've never heard it.
They're called off-year elections. They are called off-year. Yeah. We will. That's part of what we can do and why. But yeah, this is now getting tossed back and forth between states. This state court said, no, this wasn't. The state court said, yes, it was. So this is why we're kind of needing SCOTUS to step in and say, hey, we need a blanket interpretation of this text so that people are protected, so that we know our jobs are protected. And it's not, well, Michigan ruled that you can't discriminate based on my gender orientation. However, Georgia is saying that if I'm gay, I'll lose my job.
Right.
This is where it becomes so important. And our Supreme Court judges have had some very, very interesting and disturbing things to say on these cases. Justice Alito suggested that it would be absurd to conclude that when Congress passed Title VII and intended to protect gay people, you're trying to change the meaning of what Congress understood sex to mean and what everyone understood. This is wildly insulting because literally 5 years later, the Stonewall riots happened. 5 years after the Civil Rights Act was enacted, the Stonewall riots happened. The LGBTQIA community was fighting for their rights at the time that the Civil Rights Act was enacted. And for Justice Alito to say that we kind of never thought that they would rise up and, fight for their rights and want to be protected as, people, and that the country could not see people wanting protection on sexual orientation and gender identity is plain bullshit. It's bullshit. This was happening when the Civil Rights Act was passed. There were riots in the streets. There were places getting raided. There were people being locked up and put in mental institutions because homosexuality was considered a mental deficiency. This was not out of the scope of possibilities at the time the Civil Rights Act was enacted. They were fighting for their rights at the time. So for Justice Alito to say, well, we couldn't have imagined that the gay people and the transgender people wanted rights is bullshit. He was alive during this time.
Well, I mean, I can imagine how somebody could see that, because there are people in my family that would say that there's no way that that's the direction we're going, and that's not real, and that's today.
Right. But this is a justice who lived during this time. Like, I don't understand how...
I don't know. I think people can live in their bubbles.
There was literally shit on the news back then that this place was raided and people were arrested due to homosexual acts. Like, to turn around and say that you don't think a person was going to fight for who the fuck they are is spitting in someone's face. Like, how?
Well, maybe he thought. I'm sorry. I'm just kind of playing devil's advocate here.
Sure.
I'm saying maybe he thought that they would. Maybe he thought that they would be disencouraged. Maybe he thought that they were losing. Maybe he thought. I mean, he was just wrong, in my opinion. But and maybe he's not.
That was the tone with raiding the bars and raiding, places of business that created a safe space for the LGBTQIA community to come to, was oppression. They were absolutely trying to put boots on their necks to say, this is wrong. This is against our beliefs. We don't think this is a quality of life for society. So shut up, stay in your homes, don't come out. And anytime you do come out and try to form or group or create a safe space, we're going to destroy it. But for a justice who is supposed to be versed in history and the law to turn around and say, I grew up in a time when people were being arrested, people were rioting in the streets for LGBTQIA equality, and there's no way that I could have seen anyone wanting to fight for this, is insulting.
I agree. I just think that some people really believe that.
As a member of the, and I know I'm getting like, fuck him, blah, 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 but as a member of that community, like, I used to drink at the Stonewall bar. Granted, I'm not old enough to have been there for the riots, but I used to drink.
Almost.
Almost. Fuck off. Okay, fuck you. I used to drink there. I used to hang out in traditional New York City neighborhoods that were always known as the queer part of town, or, the gay area, which was the Village. So I'm like, this isn't a new argument. This isn't a new fight. I've known about this now. Granted, I'm almost 40. I've known about this from the time I was a child. So how could you sit there and tell me that even 20 years, 60 years later, you couldn't foresee this happening? In 60 years of progress, you couldn't foresee this happening. When this was enacted, you couldn't turn around and say, hey, we're shitting on more people. Maybe they're going to want to fight for their fucking rights too. Or were you just hoping that, oh, we couldn't suppress the Black people, so maybe we could suppress the gays and they'll shut the fuck up?
So it's interesting because that guy probably wasn't hanging out in the queer groups. So he wasn't seeing the proof of it that you were.
Right.
But, so what can we do about that? I think that we have to just, I don't know. I think it's important that we have safe spaces. For example, here in Austin, there's the Warehouse District at night. Everybody knows that's where we go for that kind of atmosphere.
Not right now, Jenna.
Oh, no, not right now.
Not in the next couple of weeks. We're not encouraging this right now. No. Depending on when this airs, you may not be able to go out then either.
Drinks on me once it clears up.
But The reason that I got the opportunity to be deconverted was because I had the opportunity to be exposed to different beliefs than my own.
Mm.
It wasn't because people came to me and told me to believe something, because that would have convinced me to believe the opposite. It was because I started hanging out with people who, when I started saying something just ridiculous, they wouldn't make me feel uncomfortable. They wouldn't make me feel like I was an idiot or like I was ill-intended or whatever. They gave me the opportunity to feel safe with them and be exposed to a new way of life. And so I think that this is why it's so important. I don't go to family gatherings anymore
Mm.
because they're religious.
Right.
And it's all of my family members in one room and they all believe the same thing. And it's just very intimidating to me. But if I never go around them again, then will they ever have the opportunity to see that I'm an atheist, but I'm still me and I'm still a good person and I still love them. So when we go to family gatherings and people say things like, "Oh, well, don't talk about religion or politics, that's controversial and that's tough, and you just be nice." That's not being nice.
No, it's
Learn how to talk about it. We're doing it
complacent.
here. We need to probably invite somebody on that does disagree with us at some point, because this
I'll
is important.
I'll find one, y'all. If y'all ever see my social media, trust that they're in abundance.
Oh,
But
yeah.
the issue between sitting at a family gathering and a Supreme Court justice is a Supreme Court justice takes the bench, accepts the nomination on the fact that they could properly represent the people of this country. And for you to be this fucking ignorant as a goddamn Supreme Court justice is inexcusable.
Well, it seems to me like the Supreme Court is kind of two sides. It doesn't seem like any one person is trying to represent everyone in the country,
No,
because there's
they're
so
not,
many
but
different sides.
however, you take the nomination going, "Hey, I have some fucking knowledge on how the laws in this country have worked, both, on a legal scale and a progressive scale, and I feel that, yes, I have enough knowledge to accept the highest court in the land." For you to be this ignorant and say, "Well, after studying law for 50 years, I couldn't imagine that, the country would want to call for such progressiveness that other people would want their rights," is ignorant and it's irresponsible.
I
It's
agree.
irresponsible.
Can I disagree with both of you right now?
Sure.
First
Please.
of all, we only have a few minutes left on the show. I've been told we have 5 minutes left on the show.
Oh,
For some reason, they couldn't tell you that. They needed Johnny the messenger.
Let's
Yeah, but I'll make it brief. What he's saying here is, what did Congress understand sex to mean at the time the Civil Rights Act was enacted? The people who were fighting for equal treatment and fairness, they understood what they were fighting for, but Congress had an entirely different idea. And there's always going to be people that disagree, but he's just looking at what Congress is looking at. And
but just Alito did elaborate on this.
Okay.
That the public would find it hard to accept a ruling from the Supreme Court interpreting Title VII to encompass other forms of discrimination, even though the public seems to be perfectly fine with the Supreme Court enacting other legislation on the very same Civil Rights Act that is being argued here. Alito was quoted as saying, "If the court takes this up and interprets the 1964 statute to prohibit discrimination based on sexual orientation, we will be acting exactly like the legislature." He then took it even further, asking if transgender women would be allowed into women's sports, where he was reminded that this is not the case before SCOTUS.
It is not the case before SCOTUS. And
so he is addressing that, yes, Congress could not see that this was coming. However, us as SCOTUS judges could, and this is now the job ahead of us. So trying to deflect onto Congress saying, no, they couldn't do it. Again, do your fucking job. Do your fucking job.
So you think that he thinks that Congress couldn't see it at the time, but he could?
Yes. Not that he could, but that this is the place that we are at now. And it's no longer a part of what Congress could have figured out 50 years ago. The case is before you now. And this is the progressive track that this was coming to play on. You should have seen this fucking coming. You taking this as a judge should have turned around and said, hey, this is something that could happen. People are going to ask for their fucking rights because these cases have been heard over the last 30 years. So for him to turn around and try to deflect back on Congress, to me, is bullshit.
This is a matter of statutory interpretation, and different attorneys, different judges, different people who live in this world have different philosophies. Someone like Alito probably has something more of like a strict constructionist view of the Constitution and a textualist view of all statutes. In the law, we make arguments to suit our purposes. And sometimes I find myself arguing from like a strict, textualist position. Other times I'm trying to look at the statutory history, the legislative history, the statutory intent. I look at like notes, hearing notes, transcripts of what was being discussed. It depends on how far away from the obvious my particular case is.
Right.
Before we lose time, there's something I really wanted to say, and it's something that's in some of the notes that we've been sharing. There's a book called The Brethren out there, and it's older. I think it's from the 70s. It might be from the 80s. I don't know. I read it 15 years ago. It's about the Brennan Court in the 1970s. It was the court following all the great Supreme Court and legislative advancements of the 1960s. It's a book. I think it's written by staffers and clerks and other people like that. If you want to know how the sausage is made at the Supreme Court, read The Brethren.
Link that below the show too. To wrap up, I just wanted to give you guys a kind of basic overview on when we should be expecting a result and everything, and when we should be expecting opinions on these cases. Oral arguments were heard for these cases in October of 2019 are now pending result. And for the Supreme Court, and many other arguments are heard from October to April. After the oral arguments are heard, we move on to the justices' conferences. And when a court is in session, there's 2 conferences per week. And, they talk about the cases heard on Monday and Friday and everything else. Each justice will discuss the case, vote on it, and then a justice is assigned to write out the opinion of the court. After this comes the opinions, which are typically handed down by the last day of the court's term, which is June, early July, before the court recesses for the summer. With the exception of this deadline, there are no rules concerning when decisions must be released, but typically decisions that are unanimous are released sooner than those that have concurring or dissenting opinions. So we should be hearing something come next summer, June, July, hopefully.
So basically, listen, call your congressman,
also
call your senator.
You can also go on to the Supreme Court, the Supreme Court website, and actually view opening arguments, and view what they are hearing on and what their rulings are. There are some things that we can do. These kind of cases are kind of out of our hands at this point because they've already reached the Supreme Court. However, there are things that we can do that can influence it. The president selects Supreme Court justices before they are questioned before Congress. So this is why we're having such a hot debate on our presidential elections in the U.S. this year, is because it's not just the president that you're voting for. You are voting for justices that are going to hear cases like this, like abortion cases, like any case before the Supreme Court. And they're either going to nominate a liberal or a conservative, more leaning judge. That now we have a 9-judge ruling so that we don't get tied up. Supreme Court justices are for life. We have a couple of older Supreme Court justices that will probably be retiring soon. So the reason why everyone's kind of such up in arms is the next president is probably going to pick another justice. That is going to greatly tip the scales in whatever political sway that you tend to go for.
So I don't think that we have enough of the younger generation represented in politics. So I'm going to make a personal request that everyone votes.
Please. Yes. Also, Jenna, you had asked about midterm elections.
Yes.
While the president does select the nomination, they do go before the Senate to be questioned and verified to see if they can properly hold the office. And Kavanaugh, we don't know what the fuck happened with Kavanaugh, but it fucking happened. Okay, I'm sorry. But this is why
he got me involved because he was doing that. That's why I'm here.
But this is why midterm elections are so important. It's your senators that are going to be deciding on who does kind of pass through the presidential recommendation of who's going to sit on the Supreme Court. However you decide for your senator, these are the people that are going to be making these decisions for you. These are the people that decide who is going to be interpreting the highest laws in this land in the U.S. So pay attention to your midterm elections. It's not just the presidential election. 6 years, I vote in every midterm. There are commercials for senators. You can go on PolitiFact. You can go on many fact-checking websites to read a senator's voting record to see if this aligns with what your beliefs are and what you feel your morals are and how you want this country to be run. Also, like I said earlier, the Supreme Court website lists all of their cases, opening arguments, closings, opinions, everything. Keep up to date on that. It is all public record once they're heard. You can keep up to date. You can pull whatever you need to. Oyez is another fantastic website for Supreme Court cases. It's mainly about keeping informed.
And
Keep informed
talking.
and talking.
Talk to your friends. Talk to your family. Talk to people.
Call your senator's office and say, hey, if we do have, granted, hopefully we can RGB, we can hold her, somebody protect her during COVID because she's the important one that we need right now, please. But, justices die, they get older, they retire. Contact your senators. If there is a justice that is being nominated and you don't agree with why, make noise about it, write letters. Protest at your Capitol building, protest at your senators' offices, make sure your voices are heard, but research. Every senator, every president who's been in politics has a voting record. Research them.
And we will provide what we can.
Right. And we will be here to provide what we can. Our more liberal justices, of course, are swaying towards no. These people are protected. However, our more conservative justices are throwing into courts transgender bills and bathroom bills and women in sports to try to deflect the rest of the justices into saying, hey, we're conservative. Does this lead to this? Does this lead to that? Does this lead to this? Call on your senators to say, no, these justices need to argue the cases held before them and not get us wrapped up in some hyper super pandemic like, well, if we let them do one case, it's going to be all the cases for all the gays. And so what if it is? So what if every gay person who's ever been discriminated against in this country, every transgender person, every non-binary person brings a case to their local courts? If you have been discriminated against and you feel that it was in violation of federal right, file the lawsuit. Make sure that this is heard. Make sure that we're saying we're not going to be silent anymore. And make sure that the laws can be changed.
Reach out to GLAAD. Reach out to the ACLU.
Yep. Freedom from Religion organization too.
There's a lot of good organizations out there that have information that can help you. Go to oyez.com or oye, depends. There's a split on how to say it. But you can read decisions, you can read arguments. There's some wonderful arguments. Sometimes the best arguments that will tug at your heartstrings are in the dissent. Plessy versus Ferguson is the one that comes to mind. Brown versus Board of Education. These are great decisions.
That's one of my, before we wrap up, I got caught up in doing this episode. I wanted to address a mistake that I made on our last episode. I got my research confused. It's not the mercury that we produce that we create more of than we're found in vaccines. It's actually the mercury that we're exposed to on a daily basis through food, through other environmental factors. So I did want to clear that up, that it was not the mercury that we produce within our bodies that is found more in vaccines. It is the mercury that we are exposed to in our environments every day. So wanted to clear that up. I'm hoping we can switch that around a bit. Thank you, Johnny, for joining us today. It was so nice to get someone who's actually like, no, this is how it actually works because I've done it. Jenna, thank you as well for just being here and being just, how does this work? Because I've been in a long time and I forget that not everybody knows. So remember, everyone, don't just sit and bitch.
Get up and do something.
Thanks for joining.
What are we doing, man? What are we doing?
No, you're done.